Hello. Today we're going to be talking about whistleblowing policy, and we've been invited into the offices of DLA Piper in central London to talk to Simon Airey, one of the leading thinkers on this subject. Thanks for inviting us in today.
Thank you, very welcome.
Simon, if you could just set the scene for us. Whistleblowing seems to be such a hot topic at the moment. It's been talked about in news, newspapers, and magazines, online. What's happened? Why is this such a critical issue right now?
Whistleblowing is a really hot topic at the moment. It's a combination of factors. The economic downturn, the financial crisis, people losing their jobs have all created an environment in which people are ready to complain. The law differs from country to country, but in many instances it's not difficult. We can understand it and we can have a proper compliance program to deal with it. But what has changed is the environment of enforcement of the law. So take bribery and corruption as an example. That too is a hot topic. The source of information comes from many different places, but whistleblowers are right at the heart of that. Speak to the Department of Justice, to the Serious Fraud Office here in the United Kingdom. Every single time they will refer to the value and the importance of information coming from whistleblowers.
Could you tell us a little bit about the Dodd-Frank Act? Obviously it's an American piece of legislation, but is it relevant for companies in the UK?
The Dodd-Frank Act is an extremely complex and far-reaching piece of US legislation. One of the core features at its heart are protections and rewards that are given to whistleblowers. In fact, if they give relevant information that may result in a financial sanction of greater than $1 million, there is an ability to award the whistleblower between 10 and 30% of the total award. So, for instance, in a case just 2 years ago, a leading investment bank was the subject of a whistleblower. That person, in fact, went to jail as a result of their complicity in a number of those events. But when he came out of jail, he took advice and he was ultimately awarded $104 million. That means all of a sudden that employees are incentivized to go direct to the regulator, not necessarily to their legal department or to their compliance officers, but to the regulators themselves. To try and counter that, we've seen some companies setting up their own whistleblower programs internally, offering employees rewards for speaking up, which is another expression that's been used to try and take away some of the stigma that is sometimes associated with people revealing what they believe to be, often in good faith, issues that relate to a lack of corporate compliance, a poor culture, or put bluntly, gross breaches of the law.
Simon, how important is it that organisations have a clear and coherent whistleblowing policy in place which is communicated throughout the whole organisation?
It's absolutely essential for a company to have a properly constructed, a tailored whistleblower program that suits them and is proportionate to the risks that they detect or that they perceive all around their business or in different parts of the world. The danger, if they don't have a portal for their grievances or their concerns, is that they will go to the public. They will go to the press or they will go to a regulator. There's an increasing fashion for people to set up their own blogs on the internet or to add comments to the websites of major corporations. At the moment we have a major motor and engine manufacturer under investigation around the world for allegations of bribery and corruption that were first made in public on the internet. Very difficult to erase once they're out there, often reproduced by other news organisations and without a doubt often picked up by the regulators themselves. Speak to the Department of Justice in the United States and they will tell you that they read the newspapers, they capture logs, they have search engines looking for certain terms and phrases that could be their first point of alert when it comes to grievances or allegations of criminal conduct. Bearing in mind that there are a whole range of different types of whistleblower. Some of them, quite frankly, are delusional. Others of them are very well intended but are mistaken. Some are well intended and correct. Some of them are malicious and correct or malicious and wrong, but it's very important to understand the type of person that you are dealing with. But the bottom line is that all of them have got to be treated seriously.
How much information comes into the hands of regulators?
There is a vast amount of information that comes into the hands of regulators. In fact, their greatest problem is deciding how to sift with that and which to treat more seriously There is a huge amount of cooperation between regulators, and one of the great difficulties for a corporation is the concern that if the whistle is blown in one country, information comes into the possession of a regulator there, almost automatically in many situations it will be exchanged with regulators across the sea. And that will often mean that a company is facing an investigation at the same time in two completely different legal jurisdictions. And that brings with it a whole range of different headaches. Does privilege apply? How is data to be extracted? Do companies face the double jeopardy of being prosecuted essentially for the same thing on two sides of the ocean? Headaches that are legal conundrums certainly, but once they come into the hands of the press, a completely different ballgame as well, requiring mass mobilisation of advisors with all the expense and the delay and the pain that goes with that. Often better to have policies and procedures that work and to have them properly implemented to avoid all of that type of nightmare. In fact, David Green, the director of the Serious Fraud Office, was recently here at DLA Piper presenting a seminar. In fact, I've got a quote from him here. He says, "We get whistleblowers every day. Some are bang on the money and some are unreliable, but every one gets looked at. You'll be stunned by the numbers."
So finally, to sum up, what are the key messages that you would really want HR directors and compliance directors to understand on this subject?
Absolutely essential to have a functioning policy in relation to whistleblowing. One that is properly resourced, one that has the support of the board, one that is properly implemented, upgraded, monitored and reviewed from time to time. Make sure that it functions, make sure that people in the company know that it's there and that it works. If they don't have faith in it, they'll go to someone else. And of course, if they go to someone else, you've instantly lost control. It's too late. The regulators are involved, the press are involved, the public involved. When you see your share price plummeting, the board are going crazy, it's very difficult to retrieve that situation. It's a disaster recovery program rather than something that you have a degree of influence over. So I come back to the point. Have a policy that does function. Make sure that it's proportionate. It needn't be a vast investment, but there must be that investment. And it's a small one. Speak to your advisors. Make sure that you get proper legal advice so that key features such as privilege, data protection, and all the usual features you would expect in a fully functioning program are in fact available.
Simon, thank you very much for your time today.
Thank you.